Carriers profit from you doubting yourself and doubting your client. Every lowball offer is designed to make you fold. My name is Taylor Ernst, 2024 California Lawyer Attorney of the Year, got a $63 million verdict, wrote the book on TBI litigation. It's called The Ernst Way. I do 3 to 5 calls a week with lawyers that I basically help them get the money. If the case is under 5 mil, we just give it away for free. You're not worth bringing us in. We figure, hey, how can we figure out a way to make all the other TBI cases in the country get more value for their clients? This is how. There's no secret. We want to give it away. We want you to litigate your TBI cases better. So let's get to it. When insurance carriers offer money on one of your TBI cases and you think, wow, they don't get it. Undervaluation isn't ignorance, it's design. The offers that the insurance company gives you, those are the most real data points of how the carrier views your case and the risk that you have to them as a lawyer. Once you begin understanding the insurance offers correctly, you stop wasting energy about trying to educate the defense and you start focusing on what actually will move the needle, because everyone wants to talk about educating the defense and white papers and better science. That all helps, but that all helps through the lens that the insurance company sees it. Is they will talk to their defense expert, a defense neurologist or neuropsych, who translates what the medicine is that you try and educate them on. So it's like the game of telephone, you know, the 5 people lined up, one phone call, next phone call, next phone call. When you give new information to the defense, the only way the insurance lawyer and the insurance adjuster hears the information you give them is based off what the defense paid neurologist, who does 95% work for the defense, tells them. And so when you're trying to educate the defense, that's not the goal. You want to add significant risk profile to them in some way, through leverage of going to trial, through the medicine the defense can't disagree with, or through things that where the defense lawyer is telling the adjuster, hey, this is a really compelling story. We should listen to this more. We assume that the defense lawyers, defense experts, and the defense adjusters don't understand TBIs. I fundamentally disagree with that. I probably hear somebody tell me once a week on the multiple people reaching out to me, hey, Taylor, what about this TBI case? And is this something you can help with? And what are we going to do? The most consistent thing I hear from lawyers is they don't understand this TBI case. And I think that it needs to be adjusted in the frame. The defense does understand the TBI case. They understand the risk profile perfectly. They just don't think that the risk profile you've given to them makes it significant enough to give you the number that you think it's worth. When I was a younger lawyer, when I got an offer that I didn't like, I'd respond generally with more records, more, hey, I can go get another expert and give them more testing, or I'll get another MRI scan, or send them some articles that are peer reviewed that my experts say are great. I don't think that moves the needle, because when the defense expert looks at all that stuff, it is extremely unlikely that that expert has not seen that before. So we get frustrated when we do all this work that doesn't move the needle. But just breaking it down, work doesn't translate into better offers. The only thing that translates into better offers is something that the defense expert will go, ooh, we have more risk on this case than I thought we did because of this thing that I agree with. And finding facts that the defense expert disagrees with is pretty tough. So fundamentally, going back to what I said in the beginning, undervaluation isn't a mistake. It's the defense tactic. It's deliberate. And you know this when you read, after you get an excess verdict bigger than the insurance policy, when you go to read the file in the bad faith case, you'll see things like what they perceived as the risk and the undervaluation compared to what you think it's worth versus what they think it's worth. It's their business model. Every time they pay out money, it isn't getting the value right. It's breakage. It's a loss. If they have to pay you $5 million in a TBI case, that's not getting it right for them. That's a $5 million loss to the insurance company's accounting bottom line. So let's make this clear. Undervaluation isn't a mistake to correct. It's the deliberate plan of the insurance company to put pressure on you to make you think they don't get it, hoping that you don't roll the dice and go to trial. So the offer, more than anything else, tells you how they see you. So let's say there's 5 offers before trial in your specific TBI case you're working on. The offer itself is the evidence. That is, of all the BS the lawyer talks about and the banter that goes back and forth in the litigation, or if you turn scorched earth pretty early, the non-banter and everyone's just mad at each other. The whole concept is when they give you an offer on your case, that is a single point of evidence that's the most likely representation of how they view your threat level. And I think we need to lean into that more. If they give you a really terrible offer, what they are telling you is they don't view your case as significant risk. And that's okay. You just need to understand what it means. I've tried cases where quite literally before I get a $5.65 million verdict, the offer to me and my client is zero. The offer to us before I think we got a $63 million verdict, I think was 50 grand. And the reason is we didn't project risk in a way that made the defense understand the level of threat they were dealing with. And that's okay. It just means to me, the evidence that I was able to give them wasn't very good. So what we need to do is when you look at an offer from the defense, you want to understand that's the snapshot the defense is giving you of the risk profile of you and your specific set of facts. So if you then do things between you get that specific first objective test or objective number, and then you do some stuff and it goes up, you can understand what you did that made that number go up. Whereas if I've lost a motion in limine to where all of a sudden the defense offer dropped in half. And well, my ability to project risk on the defense after losing that motion in limine went in half. Or a similar thing. I had a motion to compel one time and we were taking a deposition in Germany and we lost it. And all of a sudden the defense ability to negotiate significantly dropped after we lost our ability to take that depo that we really wanted. So every move that we make should increase not the defense understanding of our TBI case. Assume they do. Assume they are making all the best moves and they inherently do understand the medicine, or at least their experts do. You should view the defense ability to respond to you with more objective numbers as whether or not you're going in the right direction. So how do I think about this and how did I come up with this whole concept? Everything that we do negotiating is risk adjustment. And the more likely we go to trial, the more likely the defense views it as risky. And I know this because I do the same calculation. I was a pretty young lawyer and I had a defense lawyer call me up and I think he just thought I was a young lawyer and didn't have any aggressive nature to me. And so the defense lawyer was basically bragging to me about how he had never lost a trial. And he talked not with me, but basically at me for the better part of 20 or 30 minutes before he told me he'd never lost a trial and he'll never lose a trial. And being a young lawyer, I should be worried about going up to trial against him because he's so good, he never lost. And I remember while he was droning on, thinking about him telling me he never lost and inherently thinking about my case, and he never lost, but my case was pretty decent. And I remember cutting him off at one point, just being like, stop. And he was like, what? And I said, you know that offer that I gave you to settle the case? And he's like, yeah. I said, my offer just doubled. And he said, what? You haven't given me any new facts. I said, yeah, but you gave me some. And he said, what do you mean? I said, you told me you've never lost, which really what you're telling me is you take no risk. The best lawyers take risk. They have cases that need to be tried and they know they may lose. The best trial lawyers have all lost big cases. And when you tell me you never have lost, you've told me you take no risk. So my offer now is doubled. He absolutely lost it. He yelled at me. He was really mad. But fundamentally, at the end of that case, he paid me because he knew that I was more likely to go to trial and he wasn't willing to take the risk to mess up his perfect record. Another example of everybody views it as the facts of the medicine are what drives the settlement values of the TBI cases. And they are the facts that you are within trying to figure out what the risk profile is. But I have a time where I was on the receiving end of thinking, oh my goodness. And where it was a defense lawyer who showed up to take one of my expert depos. And it was the scariest expert depo I ever sat through. It absolutely terrified me. I can remember leaving the depo and actually being like shaken to my core, feeling incredibly uncomfortable and being like, oh my God. And my, oh my God, it was from the fact I knew the case was no longer going to settle. And the way that defense lawyer did this to me was the signals he sent me during the depo. He didn't attack my expert at all. He said, what is your opinion? What is the basis of that opinion? What's your next opinion? What is the basis of that opinion? And his questions were so specific, precise, and on point. They were trial lawyer questions, no fluff, and he didn't attack my expert at all. But it changed my perception of how the defense viewed the case, which I realized they weren't going to offer more money. And the only way I was going to get that case settled or get the most money out of it for my client was be able to destroy one of their experts so significantly they'd have to fundamentally reevaluate the case. But the concept was he put risk in me based off taking such a trial depo that he wasn't attacking my expert because he was, as I call it in other videos, saving all his powder for trial. Like, he didn't want to fire all his musket balls at me or cannonballs at me. He didn't fire a single one. He basically said, what are your opinions? How did you get to those opinions? What did you consider? Did you consider this? Did you consider that? Did you consider this? Did you do anything else? No, nothing further. I think it was an hour and a half, maybe an hour depo. It scared me so badly. I remember, I can't even tell you what case it was on. I just remember that case because I remember thinking, I'm trying this case 100% because of the way the lawyer took that depo. The other way you can track the defense threat perception of your TBI case is the way they interact with you at depo. Now, I started as a young lawyer, as everybody does, and I've been at depos where they laughed at me. I've been at depos where they've mocked me, sometimes off the record, but I've been at depos where they mock me on the record. They make fun of my questions. They make fun of me not understanding it. They make fun of how long I'm taking. And over time, as my threat level has gone up and up and up, and I've been stacking proof of the wins that I've gotten over and over and over again, it started to be where I meet defense lawyers and they saying, yeah, we know this is a big deal. Yeah, we're taking it really seriously. Our carriers told us this is extreme exposure and we need to figure this out. And so they've recalibrated the threat level for me in the career that I've had from the beginning to now. And the way the defense interacts with you is another sign, as strong as when they make you an offer. But I do think it is a way for you to judge how you understand what the defense thinks of you. If I had to sum it up in one thing, read the offer numbers as their threat perception of your case, not the noise. Don't listen to what they're telling you about. Don't listen to their theories. The number of times I've had defense lawyers say, this isn't a real TBI case. I don't know why you're calling it a TBI case. And then at the end, pay 8 figures for it because it was a TBI case and they knew that the whole time is really high. What they say doesn't matter, but the offers they make to you should allow you to recalibrate what works and what doesn't work. Use them as the signals. When the defense basically says, hey, we don't believe you, we don't believe you, don't believe you, and then adds another $2 million to their offer, you can ignore what they say and follow the signals, which, if you can get the takeaway from this, focus on raising the perceived risk of your TBI case. Don't educate them on the medicine. Educate them on what the medicine means. Just because your client has a balance issue doesn't mean you give them more proof of they've got a balance issue. You give them proof that the balance issue means that they're now using a cane at 57, and at 57 using a cane means they're a fall risk, and all of a sudden your specials for the future, because they're using a cane, means by the time they're 65, they're going to have an even higher fall risk and they're going to need someone in the house, which means you're going to ask for an additional $2 million at the time of trial. Where, to sum that up, fall risk, balance, $2 million more of care that you're going to be arguing for to the jury. Then all of a sudden the defense will take that more seriously because they have a number that they can specifically track, run up the chain and say, hey, we need to really see about this number that Taylor's working on because, you know, what was the $3 million life care plan with the balance, now it's more like 5. Okay, well, now we should think about offering this much more money at the next mediation. Remember, read the numbers, not the noise. The offers are the signal. And when you get a bad offer, when you get a low ball offer on the TBI case, it's not that they don't get it. It's that you haven't been able to project risk the way you think you have. And when you get that, just take it as a signal. I need to go figure out how I can project risk in a different way that actually makes them listen to, am I willing to go to trial and what are the numbers that I'm going to put up? If you treat the offers as exactly what they are, evidence and pieces of evidence, not to your client's injury, but the ability for the insurance to understand the risk that you and this specific case put together, provide them, that's when you understand the game that you're finally playing against the insurance company. So thanks. Till next time, Taylor Ernst, TBI Lawyer Secrets.